Good morning, Your Honors.
You're muted, Ms. Grossman. Okay. Greg, you're up.
Thank you. Good morning, Your Honors, and may it please the court. My name is Steve Gregg. I represent the appellant in this case, Leon Fox, who is the former husband. The appellee is Jill T. Fox, and she'll be referred to as the former wife. I would ask the court to alert me when I have about 5 minutes remaining so I can reserve that for rebuttal and response.
Sure.
So this is an appeal from a post-judgment alimony modification action. The former husband petitioned the court to modify his permanent alimony obligation based upon the former wife cohabitating in a supportive relationship with another. The former wife moved to dismiss the former husband's supplemental petition based on Florida Family Law Rule of Procedure 12.140. In the motion, neither in the motion nor in the argument at the hearing on the motion did the former wife specifically address if it was failure to state a cause, lack of jurisdiction, or otherwise. It was simply noted that it was 12.140. The court ultimately granted the former wife's motion to dismiss with prejudice, and the former husband has appealed, raising two issues. Those two issues are first, that the trial court erred by failing to give meaning and effect to the entire alimony provision when it purported to interpret it. The second issue is that the trial court erred when interpreting the alimony provision by effectively holding that the former husband had waived his ability to modify alimony if the former wife cohabitated in a supportive relationship. Now, generally, this case involves the trial court and its interpretation of the party's MSA in determining the former wife's motion to dismiss. The party's MSA contains an alimony provision that limits the former husband's ability to modify alimony to three circumstances, in addition to the automatic termination of alimony if either party dies or the former wife remarries. The parties don't disagree about the first two bases upon which the former husband can modify his alimony. It's the third basis upon which the parties disagree. The first two bases on which they agree is that the former husband, if his income drops below $120,000, that shall be a basis for modification. And the second one is if the former husband retires and no sooner than age 68. It's the third basis they agree upon, which is the cohabitation clause that's found in the last two sentences of the alimony provision. Those two sentences read, the parties agree that the wife has physical disabilities which prevent her from gaining employment and limit her ability to do many everyday activities. It is therefore anticipated that she may, at her option, have a roommate, which roommate would be contributing to his or her share of the household expenses. So the former husband sought to modify his alimony based on that last provision. And that leads me to the first issue on appeal, which is the trial court erred by failing to give meaning effect to the cohabitation clause.
Well, let me ask you this, Mr. Gregg, because as I read this doesn't say that the alimony can be modified if he has a supportive relationship or whatever. In fact, the passage read as a whole, which we're required to do, says that it can only be modified under two circumstances. And if that's the case, is that last sentence really a reflection of what the court might consider if one of those permissible alimony modification circumstances occurs? Might that last provision affect the court's assessment of whether the wife has had a change in her need? But only in the context of the first two potential alimony modification situations.
I believe that's a possible interpretation. Unfortunately, the trial court never actually determined what the meaning of that clause was. In fact,
can't we do that? It's on paper.
Yes, your honors are in equal position to the trial court. This is de novo review. You are absolutely able to make this determination on paper, 100%. Yeah. The former husband, obviously his position is different. And I believe that the way this should have played out is since the parties' interpretations of this last provision were at direct odds, there's either one party's being unreasonable or there's a ambiguity, probably a latent ambiguity. And that should have been determined by having a hearing and including parole evidence to determine what the actual intentions of the parties were. Returning to my argument, both parties agree the standard of review is de novo, and MSAs are interpreted the same as any other contract. Rules of construction require that no word or part of an agreement be treated as redundancy or surplusage if any meaning reasonable and consistent with the other parts can be given to it. Whereas the Herbst case court stated, in construing the terms of an agreement, the court may not isolate a single term or phrase. Instead, the goal is to come to a reasonable interpretation in the context of the entire agreement. In this case, when interpreting the parties' alimony provision in the MSA, the trial court completely failed to give any meaning and effect to the cohabitation clause. This resulted in the trial court treating the cohabitation clause as redundancy or mere surplusage. Specifically in the order.
And yet, if one interprets it as I have suggested, there was no effect to give to it because one of the only two conditions permitting a modification of alimony had not occurred.
I believe Your Honor would be correct that it's a possible interpretation. I don't believe Your Honor is correct that the trial court shouldn't have to show its work when that was specifically the former husband's argument. It leaves the former husband.
Well, I don't know. We have a whole lot of case law back and forth about when a trial court is required to show its work or not. I don't think this is one of them.
Okay. So specifically in the order on appeal, the trial court stated about the cohabitation clause, and that this is a quote from the order, paragraph 10. In addition, the marital settlement agreement also states that parties agree that the wife has physical disabilities which prevent her from gaining employment and limit her ability to do many everyday activities. It is therefore anticipated that she may, at her option, have a roommate, which roommate would be contributing to his or her share of expenses. And then the trial court says, this provision does not create a basis for modification and therefore need not address the meaning of this provision at this time. By the trial court's own admission in its order on appeal, it expressly did not address the meaning of the cohabitation clause, which renders its ruling contrary to law in the former husband's opinion. Moreover, the trial court's order is at odds with the trial court's comments at the hearing on the former wife's motion to dismiss, wherein the trial court said the following to the former wife's trial counsel, quote, "Your argument is that supportive relationship is not contemplated or is not a basis. Clearly, there is commentary or thought process or words, I'll just say, put into this agreement that kind of contemplates that. So how should the court view that sentence in reviewing the paragraph its entirety? How does the court view that?" So the trial court acknowledged the cohabitation clause, and it seemed to indicate at least that it believed it could be a basis for a modification of alimony based on a supportive relationship. But then in the order on appeal, the trial court expressly stated that it did not address the meaning of the cohabitation clause.
Yeah, but does it make any difference if ultimately in our de novo review, it's up to us to interpret this agreement, whether the trial court did or did not, really kind of makes no difference at this point, does it?
I believe it does, Your Honor, because I believe this court could take two actions. One, it could reverse and remand with instructions. It could reverse the order and remand it to the trial court with specific instructions for the trial court to conduct a hearing to flesh out these issues and resolve what the actual meaning of the cohabitation clause is. Alternatively, Your Honor is correct that this court could issue that ruling, make the determination, and end the argument one way or the other. So the trial court did not expressly, or the trial court expressly stated it specifically did not address the meaning of the cohabitation clause, thereby violating the prohibition on treating words or parts of an agreement as a redundancy or surplusage if any meaning can be given to it. This requires that the order on appeal be reversed so the trial court can actually address the meaning of the cohabitation clause, assuming that Your Honors don't resolve this on paper. The former husband's second issue on appeal is that the trial court erred by effectively holding that the former husband waived his ability to modify alimony if the former wife entered into a supportive relationship. On this issue, the former husband argued the standard of review is de novo. The former wife did not say which standard of review she thought was appropriate. The law on waiving the ability to modify alimony is very clear. Parties may waive their rights to modify alimony if the language in the agreement clearly and unambiguously expresses a waiver, or if the interpretation of the agreement as a whole can lead to no other conclusion but waiver. In this case, the trial court found that the alimony provision in the parties' MSA allowed the former husband to modify on two bases: the former husband's income dropping below $100,000 per year, or the former husband retiring no sooner than age 68. But the former husband's allegations of the former wife entering a supportive relationship are based on that cohabitation clause, which is if the former wife exceeds the limitations imposed on her by the cohabitation clause. And when the trial court addressed the cohabitation clause, it didn't just fail to find that the former husband made a purported waiver and that it found it was clear and unambiguous. The trial court specifically stated it didn't even address the meaning of this provision at this time. The former husband believes this
which would actually be consistent with the meaning that I had suggested for it.
That's a possibility.
There was no occasion for the court to address the meaning of that provision because one of only two possibilities for modifying the alimony had not, in fact, been invoked.
Well, I would not agree with Your Honor for this reason. The clause at issue says that the former wife can have a roommate. And the former wife
says the parties acknowledge that it's likely that she would need a roommate.
Right, that her having a roommate is anticipated. And this would kind of dovetail with Your Honor's notion about maybe this is really a clause that's intended to affect a subsequent modification consistent with the two bases. But from the former husband's perspective, there would be no purpose to adding the proviso that the roommate must contribute to his or her own expenses unless that was meant to limit what was to occur. Otherwise, they should have just excluded the clause altogether, and then there would actually be only two bases and no third basis that we're just fighting over. We would render the limitation on the roommate's contribution to the household expenses meaningless if we find that this isn't a basis to modify alimony from the former husband's perspective. So accordingly, the former husband believes that the order of appeal must be reversed to allow the trial court to address the meaning of the cohabitation clause with sufficient analysis as to whether or not the cohabitation clause contains a clear and unambiguous waiver regarding his ability to modify alimony if the former wife is residing in a supportive relationship. If Your Honors don't have any further questions, I will reserve the balance of my time.
Okie doke. Thank you, Mr. Gregg.
Thank you, Your Honors.
Thank you, Your Honors. Good morning. Good morning, Mr. Gregg. Jane Grossman on behalf of Jill Fox, the appellate. With the court's indulgence, I would like to slowly go through this alimony provision because I think the order in which the provisions are stated provides us with a framework of the thought process that went into this agreement, this provision. And I would remind the court that this agreement was prepared by two attorneys reviewed by their clients at the time. The agreement provides that the husband shall pay $5,000 per month in alimony. This amount will not be subject to a request for modification unless, one, the husband's gross income from all sources decreases involuntarily and permanently to an amount less than $120,000 per year. Next, said alimony obligation may also be reevaluated upon the husband exercising his option to receive his Social Security benefits as and for retirement to determine whether a modification or termination of the alimony obligation is appropriate. And I think it's notable to see that in both of those sentences, the word modification is used. Now, at this point, they totally move away from alimony modification and move on to the tax effects of the alimony. And they state it's taxable to the wife, tax deductible to the husband. They next move away from the tax effects and move on to how the alimony is to be terminated. And that is upon the death of either party or the remarriage of the wife. So we have a clear order to this paragraph. We have non-modifiable with the exception of 1, 2. And those 2 exceptions clearly reference modification. Then they go to the tax effects, then they go to how the alimony is terminated. And I'd like to pause right here to point out the parties and their attorneys could have, perhaps should have, but did not include up above in the alimony modification exceptions any cohabitation clause. It's not there. The Smith case out of the 4th District Court of Appeal discusses this. And in the Smith case, 2013.
Counsel, before you go to Smith, I'm sorry, I forgot to unmute. I'd like to go back to your last point about the separate living or supportive relationship. Does the preceding paragraph, number 6, does its language that says each party recognizes the right of the other to select his or her place of abode and the right to live with any other person if he or she should so choose, does that have any impact on the application if we read the contract, because this is a contract, with all of its terms? Does it impact how we interpret paragraph 7, or is it merely just something to disregard for this legal analysis of 7?
I don't think you disregard it, but I think if you want to look at the cohabitation clause, and you're certainly free to, we say it's entirely irrelevant, this whole cohabitation clause, but the preceding paragraph number 6 would relate to the cohabitation, okay? But in the Smith case, the court affirmed the trial court's judgment on the pleadings where the former husband petitioned to terminate his alimony on the ground that the wife was in a supportive relationship. In the Smith's agreement, as in the instant case, the parties provided specific, narrow circumstances under which the alimony could be terminated. And the appellate court held, to be sure, the concept of a supportive relationship as a possible termination event was something the parties could have contemplated at the time they entered into their agreement. So our position is the Smith case is perhaps the most applicable to the facts of this case. And I'd like to clarify something, because in your plain vanilla type of marital settlement agreement, you do not have to put in there a cohabitation clause in order for that to be considered by the court. That's provided by statute. If that is an occurrence, the court can consider it. But the distinction is when you have an alimony provision that says the alimony is non-modifiable with the exception of, and you then start listing exceptions, that's where you need to put all of your exceptions. That's the distinction in the law, according to my humble opinion. Then after the agreement goes through non-modifiable, the exceptions, tax effect, how it can be terminated, they provide, in my opinion, simply as a declaration, by the way, it is to be anticipated that the wife may get a roommate who will be contributing to his or her own expenses. It doesn't say how much the roommate has to contribute. It doesn't say permit the former wife contributing to the roommate's expenses. It's simply a declaration that this is going to be an anticipated circumstance.
And is it your position further, Ms. Grossman, that because that's an anticipated circumstance, the effect is to sort of take it out of what could be construed as a remarriage under 6114? Because I think, okay.
Yes. And I would like to clarify, and I agree with Judge Northcutt, this does not mean that this cohabitation and the circumstances of a cohabitation can never be considered by the court. It's simply that it's not one of the grounds specified for modification. If and when the husband is able to file a pleading, for example, retirement or his income changes, I think then the court can look at both parties' circumstances as it impacts an appropriately pled ground for modification. But in and of itself, I don't believe the cohabitation provides the husband with a ground for modification. Another example would be, I think if in an agreement, if the parties said the alimony is non-modifiable with the exception of A and B, and then they later on said, oh, and we anticipate the wife may receive an inheritance. And then after the agreement is signed, the divorce is over, the wife receives an inheritance, and it's way more than anybody ever dreamed she was going to get. The fact that she got more than anybody dreamed she would get in and of itself is not a ground for modification. But if the husband in this case did file for a modification under an appropriately pled ground, then the wife's income from all sources and including an inheritance could be considered by the court. But in and of itself, it's not a ground for modification. In our opinion, there's two grounds for modification. The cohabitation is merely a declaration of an anticipated circumstance. And I think the trial court got it completely correct when he said, this is not something that I can consider as a ground for modification. I'd like to address the husband's argument that a waiver must be specific, and I would agree. However, this court in the TAP case authored by Judge Casanueva, you wrote, the parties may waive the statutory right to seek modification of alimony provisions in a settlement agreement if the language in the agreement clearly and unambiguously expresses waiver, or if the interpretation of the agreement as a whole can lead to no other conclusion but waiver. And that's exactly what we have here. So I would ask the court to take a look at the alimony provision, look at its logical progression, how the attorneys felt it important to put the grounds for modification, the declaration of an anticipated circumstance, agree with the trial court, and affirm the order of dismissal. Thank you.
Thank you, Ms. Grossman. Greg, you're up. You're muted, Mr. Greg.
You'd think I'd learn after a year.
You know, me too.
I've started to realize why my grandmother hated technology. So one of the things that Ms. Grossman said was that the cohabitation clause is merely a declaration. If that's the case, I don't see how that's different from just saying it's meaningless fluff, which would appear to be the point of their argument. However, what happens if the former wife exceeds the limitations imposed on her by the cohabitation clause? So what happens if she engages in a supportive relationship where the alimony being paid by the former husband flows to the former wife? Then the former wife wouldn't be having a roommate who's contributing to his expenses. She would have a roommate who she's supporting on the.
You're assuming that this sentence or in this paragraph is a limitation on what she may or may not do. But
I
it
would,
says that the parties will anticipate, they anticipate that she would need a roommate to share expenses and to help her physically, I suppose. But
well, but we're forgetting the most important part of the clause, which roommate will contribute to his or her own household expenses.
okay.
From the former husband's perspective, this was a specific limitation to prevent her from, say, having a boyfriend cohabitate with her and both parties living off the former husband's alimony payment. Or conversely, the former wife residing with a roommate, and the roommate is taking care of her completely in a marriage-like circumstance where they are cohabitating in a romantic relationship and they're providing support. Otherwise, that clause would have no meaning if it can't be used presently and only prospectively. Excuse me. There was something else, the TAP case that Ms. Grossman brought up. And the TAP case, the former husband cited in his reply brief, in his initial brief for the second issue. And in that case, the parties' marital settlement agreement had an alimony provision, and that alimony provision awarded the wife with permanent alimony to be paid periodically to the former wife. The alimony further contained the following clause: the wife's alimony shall be reduced on a dollar-for-dollar basis each dollar the wife receives from retirement accounts of the husband, or when she begins drawing Social Security or other retirement-like income. Finally, the alimony provision's last sentence states the parties further agreed they will not have to come back to court to litigate a modification of the final judgment as a result of this provision for an automatic dollar-for-dollar reduction except for enforcement. Now, that went before the trial court on a motion for summary judgment, and the result was that the trial court agreed and found in favor of the former husband and against the former wife, who had supplementally petitioned for an upward modification of her alimony obligation. That case came before this court, and on appeal, this court held that the trial court erred as a matter of law by concluding that the last sentence of paragraph 8 constituted a clear and unequivocal waiver of the former wife's right to seek an alimony modification. Additionally, the court held the trial court's ruling ignored the restrictive nature of the key phrase in the last sentence. As a result, quote, which is as a result of this provision for an automatic dollar-for-dollar reduction. This phrase modifies the language expressing the agreement of the parties not to have to come back to court to litigate a modification, and limits their waiver of the right to modify to the automatic dollar-for-dollar provision. Well, just as in TAP, in this case, the court effectively found that the former husband waived his ability to modify alimony based on the former wife entering into a supportive relationship. But however, in doing so, the trial court completely ignored the cohabitation clause. The former wife's ability to have a roommate is restricted to one who will contribute to his or her share of the household expenses. By restricting the former wife's ability to have a roommate to one who contributes to his own expenses, the alimony provision leaves open the former husband's ability to modify should the former wife exceed the restrictions imposed on her by that limitation. The other case that was mentioned was, I believe, the Smith case, and I would offer for your honors that this case is much too dissimilar, really, to be applicable in this case. In Smith, there was an absolute and blanket waiver of alimony. The alimony provision stated, said alimony shall be non-modifiable by the parties in either amount or duration, regardless of any circumstance of the parties. And then it states what the termination clauses are. So that was a blanket modification. And once the former wife began engaging in a supportive relationship, the former husband petitioned to modify or terminate his alimony, and the trial court properly denied it because there was a blanket waiver. In this case, there is no blanket waiver. There are two bases that are set forth at the top. There's a third basis down at the bottom. And the question is, what does that third basis mean? That's what the trial
your time is up.
And then I will conclude my remarks by simply requesting that the court reverse the order and remand the case to the trial court for further proceedings. And I thank your honor's time and attention.
Well, thank you both very much. Before you go, Mr. Gregg, is that a highwayman painting on the wall behind you?
I would have to ask Mr. Maros. I don't own anything here.
Yeah, our court has a collection of those actually, and we used to display them in our.
I will ask Mr. Maros if that's the case.
I imagine Mr. Maros has good taste. So, okay. Thank you both very much. In order to leave our virtual courtroom, you click the leave button in the lower right-hand corner of your Zoom screen.